Welcome everybody to this week's edition of Legal Ease with John Watts and Stephen Palmieri. And today we have an esteemed special guest, Mike Cardoza, coming in from California. So we are outnumbered credit repair guys to lawyers, outnumbered 2-1 today. We're gonna have some amazing content. We bring this to you guys to make it easy to understand the legal and to be able to talk directly with some consumer protection gurus. John Watts has been doing consumer protection for eons. He has an amazing YouTube channel with an awesome following. Mike Cardoza, well, he's just awesome in his own right. He has a wonderful website with beautiful pictures. Gentlemen, welcome. Mike, thank you for coming on as a guest. Thank you guys for both not using the kitten filters. I know that seems to be a thing for the lawyers on Zoom this week. What's going on in y'all's world? Take it away.
Well, we're glad to have Mike here. And Mike, why don't you introduce yourself and give people a little background? You have a very interesting background to do this type of work.
Yeah, I think like as in life, you can't really figure out how you got to where you got until you get there. And this practice of consumer protection is a real litigation heavy practice. When I get questions sometimes from clients about, why don't you just send the attorney letter and make it happen? I tell them, I don't send letters, I send lawsuits, because the letters, they don't work. We got to get into battle. We got to pray for war and try to get to trial and, do all the things that make people uncomfortable. And the thing in my background that really prepared me for this was, if any of y'all have ever seen A Few Good Men, I am not Kevin Bacon, but I played Kevin Bacon in real life, and also Tom Cruise, which is a little bit weird if you think about it, going from being a defense attorney to a prosecutor. But my point in that is that we tried these cases all day, every day, played basketball, lunch, and went out drinking at night. And it was nothing to just tee up a case against a bunch of jurors after working out at lunch in the afternoon. It was a regular thing. So I've got a really comfortable experience with the courtroom, and I find that a lot of my adversaries in civil litigation don't have that. And it's a long story from there to the next little data point, which is how I found myself on the East Coast as the owner and operator of a debt collection firm, consumer collection firm. We bought debt for pennies on the dollar and then sued people to collect, 120 cents. Just like that. And we had a big debt collection law firm, and I was involved in the industry. And that went on for about 7 years until I thought, well, this isn't a feel-good side of the industry, and there's no trials and we never win. So I'm gonna flip sides and take what I know, and now I'm gonna start smashing all my friends in the face with the wooden bat. And I've never looked back. It's been like 6 years, and it's been a ton of fun. And I just have a great time doing it. And what's great about being a prosecutor once you've been a defense attorney, or being a plaintiff's attorney for consumer protection when you've once been a debt collection attorney, you not only know what they're going to do, but you know what they're thinking, and you know what to write, and you know what they're scared of. And you can know too, the things that they get angry about are the things that they're scared of most. So I've got that and a whole bunch of other tricks up my sleeve, and I'm just happy to be here to share that.
So what I'm hearing from you is really they're scared to go toe-to-toe with the consumer protection attorney that's better looking than Tom Cruise. That's essentially what I took out of this whole thing here.
Well, everybody's taller, I think, than Tom Cruise, so I think I can probably claim that. But in joking aside, they're scared to go toe-to-toe with the strict liability fee shifting statutory damages statute that is the Fair Debt Collection Practices Act. It is just brutal when you are on the receiving end of it.
Let's talk a little bit about Fdcpa. I mean, Fdcpa / FCRA are really two entirely different animals from especially y'all's, I'm going to go Southern, all y'all's perspective. That's not even good grammar. That's like a double whatever. From all y'all's perspective as attorneys, you had mentioned strict liability for the Fdcpa. Why don't you go ahead and just take a quick minute and explain it for those of us who are listening here who run credit repair companies, may not understand all the jargon. What is strict liability? And then compare that to the not so strict liability of the FCRA.
You
Why
want
don't
me
you
to keep?
take that, Mike?
You
Yeah.
want me to keep talking?
Go ahead, Tom Cruise.
All right. Well, watch the
we like
Nielsen
you.
meter because I've been running the monologue here for quite a bit. Strict liability is fantastic. It's like, you broke it, you bought it, right? You had a margarita and you were walking around in the shop in Mexico, and all of a sudden the pot went crash, and you realize that your elbow touched it, and all the guys running over to you for pesos. That's that law right there. Like, hey, it was an accident. I didn't mean to do it. Well, if you want to say that as a debt collector, you can. You hear about this bona fide error defense, but now you got to go on trial and prove, like, see, my elbow actually is really kind of different, but I really take good care to not let my elbow bump into stuff when I've been drinking. And like, everyone's like tuned out, like, no, dude, your elbow, you hit the pot, it broke, you need to pay. And it's just this Chinese. So that coupled with statutory damages, right? What's so important about that? Well, that means that you can't get thrown out of court because the judge says, well, you didn't really suffer from these collection calls, so I'm not gonna blah, blah, blah. And you just point to the law and says, no, he's due up to $1,000 statutorily, so we're gonna stay here in your courtroom and do our thing. And then lastly, it's the shifting attorney's fees that causes all the pain, right? They're paying their attorney to defend against what you're doing to them, but then because the fees shift when you're the prevailing plaintiff, right? When you win, because you're going to win, because it's strict liability and you have statutory damages, right? You're going to win this case. They're in that old Chinese finger puzzle where, they're pulling it apart, and I tell them it's like that sniper t-shirt, you can run, but you're only going to die tired. I mean, you can fight, but you're only going to lose poor. You're paying your attorney's fees and you're paying mine. So any rationally minded collector will give up real quick and say, oh my God, what do you want to make it go away? I love the irrational collectors, the one that feel it's a personal attack and that we didn't do anything wrong, and these scum suckers are all out to get us and it's us against them. And they fight, and they end up writing big checks at the end.
Okay, so we've got the Chinese finger lock thingy. So we get that. So strict liability, they bump the thing with their elbow. So now let's juxtapose that with the FCRA. Obviously, the FCRA has statutory damages, but it's not strict liability. Can you go ahead and elaborate a little bit further?
There's the more, and so FCRA uses like the classic either negligence or willfulness standards. You find those in the common law. The negligence standard is, hey, you had a duty of care and you didn't take care of what you were supposed to, and you breached that duty, and that duty was the proximate cause of the harm. Okay, like, so, if you and I are playing with sticks or something, and we're doing like sword fighting, and we're doing the stick game, I'm not supposed to be sticking that into your face, right? But if I'm going wild at you and it pokes your eye out, probably wasn't careful enough as I should have been during our little stick fighting thing. I was probably negligent. I owed you a duty of care not to shove it in your face. I got a little wild and crazy. I didn't mean to do it, but I just kind of like didn't take good care of you when I did that. Willfulness, on the other hand, is, I'm playing this game with Steven, and there's nothing more I'd like to do than to poke him in the face. And when his guard is down, I'm just going to stick it in his eye. And then I get you like that. It's definitely willful. And what you find in the FCRA, boy, we're really getting down the rabbit hole now, but what you find in the FCRA is that reckless disregard of Stephen's face is also willful. And what's important about willfulness in the FCRA is it gets you to punitive damages. So if I'm just coming at Stephen, slashing my thing all across his face and it pokes in his eye, I was probably in reckless disregard of Stephen's face, and that was probably a willful act under the FCRA. I hope that explains it if anybody's interested.
That's amazing. So then how do you go before the judge to survive that, what we call the summary judgment, right? Where they're basically, the judge is going to make a decision whether to keep it moving forward to go to trial or not. For the FDCPA earlier, you said, well, my client is entitled to $1,000 statutory, and because it's strict liability, we're going to keep this case alive. And judge, obviously, you're kind of obligated to, versus a lot of times the bureaus win on summary judgment when they're not going up against, obviously, well-equipped attorneys like you. So how do you convince the judge not to kick it out, that that you kind of survive their standard when you deal with the FCRA?
Here's how you do it. you do your case, right? When you get your stuff, you get your information, you got to have a client that's cooperative, is going to like give you all their stuff and tell you the truth, right? If they don't give you their stuff and they don't tell you the truth, then the deal's off. They can't be a plaintiff. But if they do that and you get all this stuff and you're looking through it, you write a 10-page children's book about what happened to them. There was a prince. One day he was walking through the kingdom, and from nowhere, these riders came upon him. And they said, you're Prince Lubalot. And he's like, no, I'm Prince Argovat. And they said, no. And they stabbed him in the neck. That's the short version. But if you've got that story, then you're going all the way, because you're not filing some kind of technical BS, which is like, oh, well, because and status errors do occur and those have real damages, right? But you're not making it about like the E8BIG whatever. You're making it about a real person that tried to do real stuff and fix their life, and these were sincerely the consequences of a company that couldn't be bothered to spend one dime more on actually doing what they were supposed to be doing and investigating a righteous dispute. I hope that answered the question.
Yeah, and Stephen, maybe this will help also to give an example, because what Mike just said is mission critical. We have to tell the story, because the judge, whether the judge is kind of leaning toward consumers or toward the bureaus, the judge is a human being. And so we look at, what's the story? Because everybody wants to know who's the good guy, who's the bad guy. So as an example, Mike and I have a case in California where it's a mixed file case. And so probably most people watching will know what that means, but that just means that one person's credit report has been mixed up with somebody else. Well, we don't just make that technical. We say, well, look, here's this person. She's doing everything right. He's doing everything right. And all of a sudden they've got 15 accounts that are not their accounts. And so they tell the bureau, look, these aren't my accounts. You got me mixed up with somebody else. Bureau says, we don't care. We're keeping it because we're incompetent and we don't want to spend any money investigating because we lose money investigating. And so we don't care about you. Well, now we have the story of, it's contemptuous and it's arrogance and it's just disregard of our rights. And so, where people lose to the bureaus is where they haven't done their homework. Either they brought a bad case or they brought a good case, but they got lazy and they wouldn't spend the money, because Mike and I can tell you, it costs a lot of money to prosecute these cases. They wouldn't spend the money, take the depositions, get the experts, whatever they need. And so if we do it the right way and we have an actual error and we told the bureaus, this is the error, and they refuse to fix it, then we're in good shape on that. And that's really the key is, for the folks that are watching this in the credit repair world, try to make your letters tell a story. And it doesn't have to be quite as, exciting as Mike's story there. But, we, even in the letters, if, for example, we're about to lose a house that we're doing a lease purchase on. If we don't get approved by next month, we lose this house. We'll tell that in the letter. Hey guys, if you don't fix this, I'm going to lose my house. I'm going to lose all the money I invested, or I'm going to lose my security clearance. I'm going to lose this job. Like, tell the bureaus that. Now, they're not going to look at it, but that's okay. The jury will look at that. The judge will read that and say, wow, they told you and you didn't do anything. So,
let's dive in. Let's dive in, because you had mentioned an actual error. And although, probably our audience could spend the next hour listening to Mike Cardoza talking about glass slippers and toads and frogs and things like that with his fairy tale. But what we really want to know is, how do we as credit repair companies find the quote unquote actual error and then put them on notice to where, we can team up with folks like you, which obviously you guys are all just a Facebook message away. That's why you're here. You're here to work with our industry. You guys are just a glorified form of credit repair, really. You just have the legal stick behind you. But let's talk about that actual error. One of the big things that I talk about all the time in here and in a training course that we do, and is Metro 2 is their industry standard. And it doesn't matter what bureau it is, they all conform to one industry standard that they created. It's not even like a standard that they adopted. They created their own standard, the big four bureaus, including Innovis. And so the big thing that I share with folks is, kind of the old school philosophy of, well, what is it? Like, what is accuracy? Which is what all the law books say too. They say, well, it's obviously not defined in the FCRA, so you have to figure it out. Well, the FCRA says that maximum possible accuracy is the standard. Their industry created Metro too. So, and as Mike said earlier, it's kind of like a negligent, willful, reasonable procedure statute. And so, I mean, the precedent's pretty clear that if an industry doesn't follow its own procedures, that they really can't justify that their procedures are reasonable, right? We created the standard, but we're not conforming to it. So like what I share with folks is, you've got this industry standard, which is called Metro 2, which is really just a fancy name for a data format. So, no matter whether you're Capital One or Midland or LVNV or whoever, you use the same format for reporting information. They hit submit one time and it goes to all three bureaus. The identical data set goes to all of them, but then somehow mysteriously and magically, by the time it leaves their database and gets printed on their little template to the consumer, it is no longer Metro 2 format. It's their whatever format on their whatever template they're going to give you. So like what I share with folks is, hey, I mean, the best thing you can do is audit the data, the trade line against the bureaus, and you don't even need to know how it's supposed to be reporting if you know one thing for a fact, which is Metro 2 is their standard. So then you just audit it and you look for the inconsistencies and put them all on notice. And at some point, unless you get 3 identical reports, you're going to get 3 unidentical reports back. And some way, somehow, somewhere, somebody messed up, right? So, what do you guys feel about that? And, what do y'all do because you said that if you do have a bona fide error, a genuine error, a reporting error, what kind of standards do you guys use for identifying errors and then obviously making the assertion to the bureaus in a dispute of it's inaccurate and here's why it's inaccurate, right? Because like comparing it to the FDCPA, like you were saying earlier, Mike, it's kind of like, well, you called me at 6 in the morning and you can't call me till 8 in the morning. And here's the phone list showing you called at 6 in the morning. So you violate it. It's not really that clear with the FCRA, it's inaccurate, but here's why it's inaccurate. And you have to kind of put them on notice and justify it. So how do you guys establish a high level of confidence with your disputes to where you feel strongly that you can take these cases and you're not going to lose them?
Well, let me say a couple quick things and I'll let Mike address that. So there are a lot of court decisions that say simply violating Metro 2 is not the same as violating the FCRA. Now, again, we go back to that's people not doing their homework. That's people, frankly, being lazy. Just say, well, here's Metro 2, you didn't follow it, so therefore I win. Well, that's true in a sense, but it's not true in court. So we have to still show that it's negligent. And so we need Equifax swearing under oath. Yeah, Metro 2 is the standard, experience swearing under oath. And so we've got to lay that out and when we're in court, but backing it up to a dispute letter, it's exactly what you're talking about, that you look at the different credit bureaus. And if one says I was 30 days late in January and TransUnion says I was 60 and Experian says I was 90, well, something's wrong. Maybe one of those is right. Maybe none of them are right, but all 3 of them are not right because it can't be that way. And so we point that out. And I'm curious about Mike's thoughts on this. I think we should point out, here's the inconsistency, and then say, and this is why that's important. This is why that matters. Like, I need you to have the correct date of last payment because I need the date of first delinquency because, and explain it. Again, it comes back to that story. So we're kind of marrying the technical with the story. Again, not that the credit bureaus are really going to look at this, but a judge or a jury looking at it later. And so I'm curious, Mike, when you do your disputes, how do you structure those?
Let me say up front that I think this Metro 2 fact-based disputing is absolutely the gold standard of credit repair. It is the one way that you are going to get deletions that would never even occur to us to be cases. And it's the one way that you are going to find the maximum number of particularly status error type cases that could be justiciable, that you could take before a court and win. So just because Metro 2 isn't exactly the legal standard for what wins, don't think that it's not the gold standard for credit repair, because I believe it is. I believe it is. Anyway, you don't have a case if you don't have damages. And also, although the FCRA says that you got to have an objective inaccuracy on the credit report or something that's misleading in order to have a case, you don't want to go as an attorney down the road of something that's misleading. And the reason why is because the opposition wants to make more case law about facts that are not misleading when it comes to FCRA litigation. Okay, if you missed that, it's not important. What is important is that to make a solid case, we're looking for an objective inaccuracy, something that is wrong, doesn't have an underlying legal dispute. I didn't leave my apartment carpet all dirty and I shouldn't have been charged $800. That's not appropriate for the FCRA, because now there's an underlying legal dispute about whether or not the money was owed. You're looking for something that's just dead plain wrong, that the consumer can prove is wrong, and that damage the consumer. And if it's not obvious, this is where experts are so important. You can get the expert usually to tell you, well, hey, didn't you know anything about automated underwriting? I mean, it takes this field from this thing. So, just because it looks like they owed $53 for an extra month, I mean, that makes a significant difference in the credit, blah, 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 on and on and on, but you got your damages. So what I'm looking for when I sue is something that is inaccurate, that we can prove is inaccurate, and that is causing the consumer harm. And that already automatically, as you can tell, helps you tell the story. I hope that answered the question.
You just kind of hang out outside those subprime lenders, like when they're having like car dealership, like, bad credit, no problem, 550 ride and drive. You just kind of hang out there, and everybody who leaves with a 25% interest rate, you just basically put them on retainer because they're being damaged, right? And you're like, look, let me just see your credit report, man, because you got damages and we're going to find the errors. Is that kind of how you market your business, Mike?
No.
No.
All right. Say anything about cars.
Let's talk a little bit, in all sincerity, though, about damages, because I hear from you guys all the time that in FCRA cases, your judges, as much as they love you guys, and you're both very likable and approachable kind of attorneys, they don't like you very much if your clients don't have FCRA damages. But now the Fdcpa, on the other hand, it kind of doesn't really matter, right? If the consumer was quote unquote damaged. If the debt collector violated, then too bad, so sad. And if I'm wrong, chime in and kind of let me know how the damages plays into both of those statutes and why there's a difference.
Look, let me take this. These are remedial statutes, okay? They were passed to fix abusive debt collection that, if you haven't seen it, it really wrecks people. Talk to somebody that's getting collected on a business debt or a subrogation debt where the Fdcpa doesn't apply, and they're getting calls, and the people are calling their friends and employees and spouses and making up lies, and it gets really weird. Like you think you're in another country that only you can imagine. So damages are very important because they raise the value of the case. And when you raise the value of the case, not only do you raise the compensation to the plaintiff, but you raise the cost of doing business this way to the defendant. And that is one of the goals of the Fdcpa, and it's also one of the goals of the FCRA. We're not, John and I, as practitioners, are not in the business to churn and burn as many of these as we can just to get a trade line deletion. If there's something just and righteous that's coming across our desk, it's our duty to our client to maximize the value of the case within their willingness to continue with litigation. So we're going to tell the full story if it caused them to have a miscarriage or extra emotional distress during the death of a parent or a loss of sleep. And, I heard once early on in my consumer practice that 99% of my clients would have emotional distress damages. And I looked at it with the jaundiced eye of a former collection attorney. And it wasn't until I started interviewing these people and asking them the questions about, well, so how'd it make you feel? Oh, I'm fine. Oh, really? Okay. Just sleeping still same? Well, not really. Okay. Can I talk to your wife? Oh, I don't know why, but yeah, here she is. Yeah, what's going on? Oh my God, Richard, it's all he would ever talk about. We were supposed to be going out on a date and he'd be like, that Amex, those bastards at Amex, they're doing this. And he's like tossing and turning. And then around that time, he started losing a lot of hair. And I saw it in the shower and he's like, you're losing hair in the shower. And I'm like, no, it isn't, Richard. It's yours. It's white. This is just an example of actual testimony about real, actual concrete damages, which is these people's experience, and they feel victimized and powerless. And at some point, they get to hopelessness. So I realize that was a bit of a tangent. I'm sorry, but it's very important that we explore actual damages and prosecute those to the fullest.
I would love to see you and William Shatner, Boston Legal, Danny Crane. I would love to see both of you guys on the same team in the courtroom. Now, although he's not a real lawyer, clearly you've demonstrated that you are one. You guys would be one hell of a duo. As a famous lawyer once said, it doesn't matter if you're right or wrong. It's really what matters is if you can convince the jury to like you. And you're a likable kind of guy, Mike, but you still failed to answer the question. The question was, why do judges love FDCPA cases, even if there's not really damages, but FCRA, it's a much more painful journey if there are no damages?
I hate both of them. Oh, go ahead, John.
Yeah, I was just going to say it's the FDCPA kind of gives an out to the judge because you get those statutory damages. And I'm going to go on a little bit of a tangent, though. I will come back and answer the question, Stephen. And that is, and this is where I disagree with a lot of consumer lawyers. They will say virtually all FDCPA cases, the client just gets $1,000. That's all they get. And I personally think that's terrible because every case that I can ever think of that I filed, we have actual damages. Now, it may be small. Okay. Of course, that's relative. I mean, I've had juries give us 6 figures for emotional distress. We've had cases where it might be $5,000 for emotional distress. And so anytime there's a violation of one of these laws, the default rule should be, I bet my client has been damaged. My job, like Mike showed us there, is sometimes you have to dig. You can't go with the first question. You got to, well, why is that? Why is that? Why is that? And then eventually they go, oh, well, yeah, it's been terrible. And so to answer your question, Stephen, the FCRA, we only get statutory damages if we get to that recklessness or that intentional conduct. And so it's a harder standard compared to strict liability, which is, as Mike described it, you bump something in the store and that falls over. So the judges are looking at this and they're saying, well, what are your damages? And here's a problem with a lot of people on our side of it is my background is personal injury. So we have a lot of trial experience. Mike was, in the military, a lot of trial experience. Most people that do this have no trial experience and they don't have any idea. How do I convince a jury of something? And so they come in and they've heard this story that, oh, nobody has emotional distress. And then they say, well, we had to pay a higher interest rate. And the judge says, well, where's your proof of that? Well, I don't know. I was lazy. I didn't get that proof. So they get thrown out. And so we have to remember emotional distress is there. And then is there economic loss? Did I pay a higher interest rate? Did I not get a raise, not get a new job? And that gap is the compensatory damages. And so the judges are looking at this. And then one other aspect that goes with this, and this is a little bit of a rabbit hole, but it's called spokio. And that's the argument that if you don't have what's called concrete injuries, and if you filed your case in federal court, you get kicked out. And so in my circuit where I practice, the 11th Circuit, there was a class action case. The defendant, the plaintiff, everybody agreed on a settlement. The judge approved it. and somebody objected, it goes up to the 11th Circuit, and they go, even though nobody's raised this, we're throwing the whole case out, the whole settlement out, because you don't have standing. Okay. And so again, I blame a lot of it on a lack of imagination and a lack of diligence on the part of the consumer lawyer to say, let's find those damages. And you can't be lazy doing that. You really have to dig, because, what if I was 30 days late, but my credit report says for that month I was 60 days late? Well, if Mike and I asked 10 of our fellow FCRA lawyers, they'd say, well, no, you don't have any damages. Yeah, you do. I wasn't 60 days late. I was 30 days late, not 60. If they're the same, then just call it 30 days late. But the bureaus call it 60. There's a difference. And so that affects me because it's something untrue. And it's the arrogance of the credit bureaus that I don't have any control over whether they report. I only have control over one thing: report accurately. And when I dispute it, fix it. And when they go, nah, then Mike can come along, I can come along and say, hey, this person's been damaged by that. So that's my little rant for.
Well, it's interesting that Spokio precedent, like you said, that you've got to have concrete damages. So what I mean by interesting, because obviously, and in fact, recently somebody had posted in our group about like, where's the unlicensed practice of law thing come in, because everybody gives advice and, we're here to help people. But if you read the FCRA, there's 1681 N and O, which say willful noncompliance and negligent noncompliance. And if they were willful, you can sue and get statutory damages. If they were negligent, you can sue and get statutory damages. That's the nutshell of it, right? There's nothing about the consumer having to have been damaged. It just simply says if the bureaus did not follow their procedures, right? If they didn't do this or do that, you can sue them for that. And then here we are, a half a century later of legal precedents, and the court cases have basically rewritten the law to where, like to your point, John, there was this case getting ready to go all the way down, and the 11th Circuit kicked it out because of the Spokio precedent. And so I think that it's really important for our folks who are listening to kind of realize that you definitely want to leave the practice of law to those of you guys, not only who have a law license, because there's a lot of you people who don't understand what's going on, but for the professionals where this is your subject matter, because, if you're out there as a credit repairer sending all these demand letters, you broke the law and you did this and you did that. I mean, that's all craziness. First of all, we don't know what's going on. That's why we need to get good at reading a credit report and putting them on notice of the facts, which is why it's wrong, and leave the practice of law to you guys. But it's really interesting. How do you reverse a whole bunch of bad precedents that strip away consumer protections? Because if the FCRA is designed to provide a level playing field against this elaborate mechanism, which is what Congress put in the very beginning of the FCRA, the bureau system is this elaborate giant mechanism. And they created these statutory penalties for violations without regard to damages. And now you've got judges that are saying, well, if you're not damaged, we don't really care, consumer. How do you go about reversing, getting new case law to erase bad case law, to get back to the original spirit of forcing the hand of these credit bureaus to actually have their procedures do what they're supposed to do, regardless of whether there's damages?
You don't need to. And we got to try to keep FCRA and Fdcpa a little bit separate, but recently the 7th Circuit out around Illinois started throwing out a whole bunch of Fdcpa cases based on the lack of Spokio, Article 3, standing, concrete injury. And the upshot of it is it doesn't matter, because you can bring a federal case in a state court that doesn't have this Article 3 requirement. And in most cases, against debt collectors and creditors, you can bring an arbitration that under the consumer rules forces them to pay all of the arbitration fees. Now that's super, super painful. So if you don't like what's going on in your circuit about FCRA and Spokio, you can bring your case in state court. They can try to remove it, but that in some cases has been held to be sanctionable behavior when they then try to turn around and argue against standing. And I mean, this really gets down the legal rabbit hole, but my point is here is like, don't worry about it. you got plenty of consumers out there who have objective inaccuracies and are trying to do something about it, and they've been hurt. And a word here on these demand letters. We used to get these things in collections. The natural theory of man. I am the sovereign nation state of Mike Cardoza, and you can't collect against me because I have my own currency and stuff like that. They're good. They're good.
Cardoza coin.
I know. I should.
The
They're good. They're good. Now I'm breaking form. Now I'm busting up. Now I'm breaking the fourth wall. Okay. Oh gosh, now I almost lost my train of thought.
Sovereign
But
citizen.
with FCRA dispute letters, the best thing you get is like a handwritten scrawl from the grandma that says like, look, I just don't understand why I pay all my bills on time and you say that I don't. And so could you please check it out by calling the gas company and give me a ring while you're at it? That is a devastating dispute letter.
So what I'm hearing you is that although you have no desire to try to overturn 50 years of bad precedent, it's very simple to get damages. And once you get damages and then change, and then play all the other games, for those of us, go ahead.
And here's something for listeners, okay? I want to put this the right way. On an FCRA case, it's not the I was buzzed in Tijuana and knocked over the jug with my drunk elbow. That's not how that works. You got to find an objective inaccuracy that you can prove is inaccurate and that's causing some harm to the consumer. Okay, that's the FCRA. On the FDCPA side, you can have the drunk elbow knock over the jug in Mexico and force, the guy to pay for it. So these are two very different tools you're using. You don't need to use I can't see my own hand. You don't need to use the FDCPA like you're using the FCRA. You just need to meet the basic elements, and then you've got a case and you can ship it out or do whatever you're going to do with it. On the FCRA, you can't pretend that it's the FDCPA and write a dispute about the broken Mexican jug because it's not going to get you there. You got to tell the whole story about the prints and the knives and the, this, that, and the other thing. So remember to keep those two things separate.
Yeah, and I think that's very important what Mike just said, because I talk with a lot of people that do merge those. Talk about sort of a mixed merge file. They mix merge the laws, and they say, oh, well, every violation of the FCRA, I'm going to get $1,000 statutory damages guaranteed. Like, well, only if it's willful, which is a pretty high standard, the way the judges put that. So if we think about what Mike said, we find the error, we dispute it, we clearly give notice to the credit bureau. Here's what's wrong. Here's why I want you to fix it. Here's why I need you to fix it. My house closing, job opportunity, security clearance, whatever. Then when they don't fix that, then you can sue them. Well, now we have some choices. So what Mike was talking about, we file in state court. And I'll just tell you, I haven't filed in federal court in probably 6 years. I file everything in state court. And then if they remove it to federal court, which I have the right to do, and then they say, Spokio, you don't have damages. I go, hey, genius, it just gets sent right back to where you took it from. And they go, oh, I didn't think about that. And so, the other option is arbitration. And so, when we're in arbitration, it's very common for the arbitrator to write a letter to the defense lawyer and say, hey, I need another $5,000 check. Because those guys are like at $700-800 an hour. And they're happy to get on an hour, 2 hour long call. When we're in court, we don't pay the judge anything. So the key for folks in the credit repair world is identify those errors, do good dispute letters that explain what's wrong. And if you can't explain why it's wrong, and I want to give you a plug, Stephen, and maybe you can give us an update. You've got some software coming out that's designed to find these errors, okay? Because it's a pain. I mean, trust me, I've got multiple monitors up going, oh, wait, there's Equifax says this. And by the time I get to Experian and TransUnion, I forgot what Equifax said. Now I got to go back, and trying to like hold, things in my mind. And so give us an update on the software. Sure. I know you are in, beta or whatever. But
we're in pre-beta right now. But yeah, about 5 or so months ago, 6 months ago, we started building a cloud-based software to bring out to the marketplace for you guys, because there's really nothing in the credit repair software arena. And we say credit repair software arena, you guys are both attorneys, and there's nothing in the attorney software arena either to really do a good credit audit. So, what we're going to do with the initial beta, you'll be able to pull in several of your popular credit monitoring reports. It'll audit the data. If it's inconsistent, it's going to let you know, hey, there's something wrong. And then you can build your templates like however you want to and have it to where it'll populate that credit data into the templates. And you can, send the same letter to all 3 bureaus and audit all 3 bureaus on one letter. So there's really nothing like that in the marketplace. And we're kind of in the pre-beta test right now. The goal is to have at the end of February to be able to start to sign up some beta folks. My IT guys, they always keep on getting a little more time from me, but so we do have that coming out. So anybody who's interested, feel free to message me. We'd love to talk to you about that. But I think it's really important to the conversation, because I think that's always been a handicap of the credit repair industry, is that you kind of resort to all the old school dispute tactics, not mine, never late, dog ate my contract, can't prove it, remove it, just because it's simply so painful to actually do what you really should be doing, which is putting them on notice of the errors. But it's not really a level playing field when you've got these paper reports or this and that, and and nobody's software does that. So the goal is to really kind of level the playing field. I've got we've got one person, she's a test user right now, and she did an entire client file in 8 minutes yesterday, from import data to audit to output every single dispute letter for each trade line, 8 minutes for the whole file. And that's putting the credit data, like inserting it into the templates and the letters, So you're sending something to the bureaus, which we all know conceptually, right? This is not like rocket science here. You're sending something to the bureaus that says, here's what's wrong with it, And so, hopefully that'll allow the credit repair industry to have a little bit of a better tool to kind of bridge the gap for that pre-litigation type concept. Because I really believe there's a lot of folks, who really do want to do good and would love to do better, if we had better tools out there. And I know we've talked to you guys. At some point, we'll get it where we can actually pull in the annual credit report and the actual bureau direct data. But right now, we're just going to start with the some of the credit monitorings, but we'll kind of go from there. But so for you guys to kind of tie that back to you guys won't really litigate off of credit monitoring data, right? Like, it's really important that if you get a client, that you'll pull the bureau direct reports. Is that kind of what your basic process is?
Yeah, the monitoring is good, but we do need to see the real reports. And but I'll say this, and I think I speak for Mike, and he can tell me if I'm wrong. But we get people all the time that come to us and they say, I've got these amazing errors on my reports, and it's so damaging to me. We say, well, let me see your dispute letter. And when we see the dispute letter, it has nothing to do with their errors. And it's just garbage. And we're like, what is this? And, we're kind of busy. We can't really put time into doing these dispute letters. So what that means is, at least at my firm, I suspect at Mike's firm, we got to start all over. This is worthless. We just wasted 6 months of time. Now let's do a real dispute. And so the beauty of this, and as soon as you open it up, I want, this program just for my own clients, but, for credit repair places to be able to do good, solid disputes, then that makes it so much easier for guys like Mike, guys like me, to be able to then say, yes, we can sue on that. So Mike, what are your thoughts about dispute letters and credit monitoring?
The better, the more, let me put it this way. The better shape a case is in when it gets to us, the quicker it's going to get filed. The quicker it's going to get filed, the quicker that trade line is going to get deleted by the defendant who wants to mitigate their damages. And if you're a pay for delete model kind of guy, the quicker you're going to get paid. If you're not, whatever, the happier your client's going to be that much sooner. We may continue on for 9, 18, 24, 36 months of litigation, depending on how much they're going to end up spending. But typically when we file suit, that consumer report's going to get fixed pretty quickly. And so the better shape you can bring something to us in, the quicker we can get it on file.
Little sidebar, but you mentioned the pay for deletion model, and it got me. I want to ask you guys something. So, typically people think that there's two legal ways to do credit repair. There's all the illegal ones, charge up front and all this other kind of stuff. But the two legal business models are basically month to month after each month, or pay for deletion. But there's kind of this new brand popping up of people doing it for free and then really teaming up with attorneys and then, handing the cases off to the attorneys and then getting compensated, somehow in that business model process. And, John, I know, you've talked with some folks who are credit repair folks who are doing that model. And for the folks who are listening, I mean, I would say the one cool thing about that is it brings you outside the scope of CROA, because if you are not charging your clients, then, CROA requires that there's consideration, right? So if you're literally helping folks for free, I mean, not that because you're not under CROA, you can be doing all these deceptive things, but I mean, I guess there is something to be said for operating for free and helping people, which is really the true spirit, I think, of what Congress wants people to do. But how can folks run a business model, embrace the pre-litigation dispute type concept, really paper these things up pre-litigation with a good working relationship with you guys? And, how can somebody legally and ethically, get compensated for that work? And there's like paralegal structures, expert structures, marketing structures. I've heard all these different things. John, you want to kind of take that one? How can somebody put a model like that together and work with somebody like you?
Yeah, and I'll say this, and this is certainly true for me. I think this is true for Mike. We don't hold ourselves out as experts on CROA. So I'm not sure that I would say that just because it's a free model, CROA doesn't apply. I think it's always safer to assume CROA applies. And, look, it's easy if you're not charging anything, but in terms of the model, I mean, there are different ways. It can be that, matter of fact, I think in about an hour, I'm talking with somebody that, they say, well, we'll build the evidence file. That's their expression for it. And so they do all the work. If it's a TCPA case, which is the robodial calls to your cell phone, they gather all the records. If it's FDCPA, they gather stuff. FCRA, they do the disputes. And so they can be compensated by the lawyer for that. So rather than me paying my own staff to do this, well, I can outsource that to somebody else. There's a marketing model, kind of depends on what state you're in, whether it's appropriate for the lawyer to do that, but to pay sort of lead generation. Hey, here's what I think is a great E8 violation, which is FDCPA. That's X number of dollars. In my state, we can't pay for that, but other states you can. And so, there are definitely models for it. The only thing I would caution people about is, we as lawyers have to be very careful because we've got to stay within the rules. And it's got to be legitimate, whatever we're doing. So this isn't a time for, form over substance. This is, hey, if I'm paying a marketing fee, then it's a marketing fee. If I'm paying a paralegal fee, it's a paralegal fee. It can't be like we're doing, like fingers crossed or wink, wink, I mean, it's got to be legitimate. And, sometimes I'll just say this. I've had a lot of credit repair places come to me and they say, hey, I want a percentage of, of what you're getting, John, or I want half of what the client's getting or some percentage of what the client's getting. And I'm going, I'm not going to be a part of that.
That's the big no-no right there.
And,
yeah.
And, so, and this is not a recent thing. I mean, I'm talking 15 years ago, I had these people coming to me saying that, and I go, I can't do that. I can't have my clients do that. But if you're pay for delete, like Mike said, that's certainly an option. And look, you set the price for the pay for delete. There's no rule that says that has to be $50 per trade line per bureau. If you want it to be $500 per trade line per bureau, I mean, it's free market. You set the price. And so that's a way to be paid. A paralegal is a way to be paid. Expert marketing. You just got to get it squared away with the lawyer to make sure everybody's comfortable. And I'll say this, that I've been practicing law representing consumers since 1995. Our rule is we have never been in a fee dispute with a client. And I don't ever intend to be in a dispute with a client. So sometimes you get a crazy client and you say, you know what, I'm backing off my fee. Same thing with credit repair. You know, you may be working with a lawyer and the lawyer says, hey, something's happened here. Everybody's got to take a haircut here. You know, you do that. You take care of the client because we've got to have happy clients and we want those referrals. And so everybody just has to be reasonable about it, but you plan ahead of time, you know, and that's going to cover 99% of the cases.
Yeah, and you'd mentioned that the expert is, one of the potential ways, and we've got our other show in this group that we do every other Thursday with Doug Miner, who's an actual qualified credit reporting expert witness. And there's different types of experts. You've got your testifying expert that you're gonna, put up there on the stand to actually testify and provide testimony and evidence before the judge, which is admissible. But then you have like your non-testifying expert, which really is, just consulting with you and providing you information. And so, that could be a viable option as well for credit repair companies, right? If they're handing you files and, maybe say, hey, I'm going to pay you, I'm just throwing, $300 for an initial, to be a consulting expert to review the case with me. I mean, is that a thing as well, or is that not a good way to use the expert to compensate folks legitimately?
I mean, it could. Again, it has to be all above board.
Yeah.
It can't be, hey, I'm paying a consulting fee and there's really no consulting. I mean,
well,
so,
no, of course, but I
know,
mean, if they spend an hour with you, and if it's $300 an hour and review a case file, and then that also kind of creates an attorney privileged relationship between you and the CRO as well, if it's that kind of a thing, does it not?
Well, I'm curious on Mike's thoughts on this because the complicating factor is depending on how the CRO is handling it, they may be sending out the letters under their name, which is your model, Stephen, or even if they're just sort of doing it behind the scenes. I mean, they're a part of this, they're a witness to this. And so, it does raise some issues with, as far as a consulting expert, but I think the bottom line is there are ways that people can be legitimately paid for the value and for the work that they do, whatever their occupation is. And so, we just have to think about it, make sure that it's, complies with all the rules. And, but there are ways to do it.
Mike, do you have anything else kind of to add to that from where you are?
A couple fundamental principles. I believe in the marketplace of almost everything that free is worthless, and you would point to, well, Facebook's not worthless, that make a lot of money, but it's not free, right? You're trading where you are, who you talk to, who all your friends are, and what you ate for dinner last night with Facebook. Okay. And they're selling that to people who are going to sell you more ribs and more going to the football game. So it's not free. So I would caution people looking at a free credit repair model, because I don't think you're going to get the same kind of customer satisfaction, and you're not going to get the same kind of upfront cash flow. You're not going to get the same kind of commitment from your customers that you would if you charged. In my practice, where we do all contingency fee cases, the level of scrutiny and skepticism from clients is so much higher than it would be if I would just charge them $2,000 or $5,000, because there's this weird reverse psychology, like, well, if you're doing it for free, you must be screwing me somehow. And so, we've really got this exceptional like customer service overhead because it's free, they have to be treated more carefully. I mean, it really is kind of bizarre and interesting. And if you don't believe me, try it for yourself, and then try funding all that overhead you need to spend on this now free demanding client with the none of the money that you're getting because you're not charging any. Fee sharing is the absolute third rail of death for attorneys. And there are plenty of other things we can do than file FDCPA E8 complaints. We could go work for a government agency. We could go be a divorce attorney. We could do trusts and estates. That we are not going to get rich doing this, and sacrificing or threatening the bar license isn't worth it in any way, shape, or form. So that's why you're going to get a lot of from attorneys if you approach them about the money. And CROs currently, and I hope they aren't in the future, and that's what we're doing here together to try to work towards, CROs are radioactive. They're radioactive, okay? And so when you see a lawyer coming too close to a CRO and they're starting to roll around each other like a binary star system, it's something that bar authorities and regulators really start to pay attention to. And while the CRO is just going to fold up and become somebody different and sell mops or brooms or dog hats from China, that attorney is somebody that they can get in and get onto and really skewer them for appearing to do the wrong thing. So I tell you all these things to tell you that you're going to get a lot of resistance from a lot of attorneys if you approach them too bluntly about, hey, I want the money. And because also there is a very small subset, in my experience, of CROs that are putting clients first. Some of them need to be reminded that they are running businesses and that they need to charge an adequate sum for the value that they're providing. There is a larger subset of CROs that are churning it for the money. As attorneys, all of us are working for the client. Now, why is that? We're not better people. We're not different business people. It's because we have this license that forces us to put the client first. So we're always going to tell the client, hey, so if they come and they're like, hey, well, do you think, is this deal that I got with Palmieri, is that fair? Like, I can't say like, well, I'm not talking about it because me and Palmieri do a lot of business. I'll be like, well, I don't know. What do you think? You think it's fair? What did he say? What did you say? I think he's ripping me off. Well, okay, it's possible. So you're going to have to contend with that attorney-client relationship. And I don't know as a CRO that you want to be anywhere near that. So if I'm the CRO, I'm charging high dollars up front. If I'm affiliated with an attorney, I'm advertising probably that I have access to attorneys and I've got some kind of pre-legal solution and it's special and different and all the other guys don't. And then maybe what I'm doing is a pay for delete, or I'm doing like a limited share on recovery with my client, remembering that they pay tax on the entire settlement amount, a lot of which includes our firm's attorney's fees. So you don't want to leave them upside down at the end of the day. And I hope those thoughts as I put them out there are, not overly negative, but just sort of a realistic outline of the landscape.
Well, I would say though, if at any point in time you want to tidy up that office, I do have some brooms and mops from communist China. So just let me know. I'm happy to sell you those and some credit repair as well.
Your side hustle. See, I don't have a side hustle.
Right. Hey, once a salesman, always a salesman, right? But that being said, it's hard to believe it's been almost an hour. I mean, what a great show, some amazing content. But so for kind of the takeaway here for those folks who are watching and want to really develop relationships with you guys and want to take their practice to the next level, what's the best way for them to get in touch with you and to kind of build that relationship? Mike, we'll start with you on that.
I mean, I'm open and notorious. I have a website. My name's Mike Cardoza. I check the face space messaging like every couple days, and once you got me, then I'm all over you with email, and we'll chat and do whatever. And I like to hear about you and what your philosophies are and how we can work together. I'm really kind of a philosophy guy. I'm a business guy, but for me, the people come first.
Is it true that you, in fact, were the attorney who went viral the other day with that Zoom video with the kitten face mask on, the kitten filter? Was that you? I heard somebody say that was actually Mike Cardoza. Was that you, or was it somebody else?
People normally think that the Fifth Amendment just applies to criminal matters, but it could also apply to just matters of gross embarrassment. So I have nothing to say about that.
No comment.
But I am not a cat. I am actually not a cat.
That's right. I'm not a cat, Your Honor. I'm actually here, and I'm willing to go forward. And John, what about you? How can somebody strike up a relationship and communicate with you, my friend?
Yeah, so Facebook Messenger's fine, or my website, which is just alabamaconsumer.com. And there's contact forms on there. And one thing I would suggest, if you find an attorney that you're interested in, what Mike said is right. I mean, I wouldn't start off the conversation, hey, my name is Joe Blow. I'm a credit repair place. How much will you pay me for cases? Because, Mike was talking about subsets. There's a very, very tiny subset of lawyers that do this that would ever even consider working with a credit repair place. Most of the lawyers on our side they talk about how do we sue credit repair places. Okay. That's just the reality. And so I would approach it with, let's say, somebody named Bob, you say, I want to meet this attorney, Bob. Well, reach out to him and say, hey, I have a client that has legitimate errors. We've disputed it. They won't fix it. I want to see what you think about it, and get on a Zoom call with them, and say, here's my dispute letter. Here's what it looked like before. Here's what it looks like after. And just explain it to them and see if you connect. Now, you may find very quickly that you don't connect, or if you do, that's great. And then I know what I enjoy doing is talking with folks in this world that, they say, well, what about disputing this way? And so we get on a Zoom call and we look at the credit reports and say, well, here's how I would do it. Not saying that's the only way. That's just the way that I do it. And you sort of, I think, will align yourself with people that, you can work with. And Mike and I have talked about this. I mean, most of these cases, kind of any FCRA lawyer can handle, because we can file it in the state that we're licensed in. I can sue Bank of America anywhere. Mike can sue Experian because they're like down the road from him. So like he could go serve them personally, I think. And so, and if it needs to go to the client's home state, well, we have friends that practice in other states. And so, you don't have to go find 50 lawyers. Find a lawyer that you sort of resonate with, you have a good connection with, and that you feel like you can work. And if that lawyer is a good person, it's going to be fair on the compensation, whether that's, hey, I'm paying you for paralegal work or whatever I'm paying you for. And that's going to be the way to find, I think, the right attorney. So
is it fair to say that, I mean, you guys can work with CROs in all 50 states?
Yes.
Yeah.
Dude, you should have just kept it nice and simple, man. You didn't have to go through that whole diatribe and confuse our audience. So our audience, if you guys are watching and you like John or you like Mike, you got to decide who you like more. That's really going to be a tough part. But they can work with you guys no matter where you are. That's really the takeaway. And that is kind of the cool thing, is that we've got, you guys, and we've got other attorneys that are kind of part of this little cult, right? Of people that, crossing over between the CRO and the attorney world. You guys are not the ones who want to actually sue credit repair companies. But you found that niche, right? And you're hitting this niche, and it's a wide open marketplace. There's a lot of credit repair companies, I think, that would love to have the opportunity to talk with you guys. So if you guys are watching and you want to reach out to Mike, John, shoot them messages. If you have issues getting in touch with them, feel free to shoot me a message. And of course, I'd love to talk with you guys anyway. If you're interested more in the training course that we do, we give a 30-day free trial. And beyond that, it's just $99 a month. And we do live Zoom trainings every single week. So feel free to message me if you want to chat about that as well. And that being said, any parting words from you guys before we wrap this one up?
Yeah, I've got one. We're here to help you. And we don't need to, you just want to call and talk about how you can identify FDCPA cases, or what, we think that a refusal to pay letter might look like. We'll just help you and just give you stuff.
Give you stuff. That gets me almost every single time, especially when I was in college. They gave me some of those little credit cards, they give you stuff. All right. So that being said, guys, John, go ahead. You got something?
Yeah, just follow up with what Mike said. Mike and I make our money, just to be blunt, we make our money by suing credit bureaus, suing furnishers, suing debt collectors. We do not make our money by selling you the super secret FDCPA dispute letter. Okay. That's fine if people want to do that. Look, if you want my dispute letter, I'll give it to you. I suspect Mike's the same way. That's not our business model to say, well, we're going to, charge you $50 or $100 or $500 for a letter. No, I mean, our business model is we're going to have relationships with a few good people, and then we make our money by suing the bad guys. And so if you want help, if you want advice, I mean, I'm happy to talk with people. And I know 90% of the people I talk to are never going to send me a case, but that's okay. I mean, I'm happy to help. I want them to do better disputes. I want them to help more consumers. And look, if we do the right thing, then good things happen.
We've actually, and Eric's got a question. It's a really good question. he says, does that mean we can say that we're affiliated with a team of attorneys? And so, I mean, obviously everything's all about how you word it and what you do, but I mean, at some point, if somebody has an established relationship with you guys, it would not be unreasonable for them to say, by the way, I've got an attorney that I've sent X number of clients to, and I have an established relationship with. I mean, is that something that's within the scope of legitimacy for you guys? How can somebody take that relationship and truthfully market it, but to where it kind of gives them a good little spin?
Oh, here's how I'd spin it. So I wouldn't, thanks. That's a great question, Eric. I would maybe consider improving on it a little bit to put yourself more in the prime position. If you say I'm affiliated with an attorney, or you limit it, you kind of give the impression that you are working with one attorney that you have a relationship with. I don't think it's as powerful as if you say, I do pre-legal litigation disputes, and then I help your case find the right place. If it needs a lawyer, I'll help it go to a lawyer, because that way you stay as the focal central point. And then, there's no question about you being the puppet on the end of some attorney's strings, or some people don't like attorneys, they don't want to go to an attorney, so they're not going to like that. So you can just say, like, look, if your case needs this and you want to go there, I can take it there. I can take it here. I can do this, that, and the other thing, and I'm all powerful. It's all about me and my CRO and what I can do and the others can't. That's how I would pitch it.
Yeah, I think that's great. And just one sort of marketing tip with that is, if you have a relationship with a lawyer, then you can always do what we're doing right now, do a Zoom, okay? And you think about it, who gets interviewed? We don't interview amateurs, we interview experts. And I'm not saying that in the sense of like in court, but I'm just saying experts are interviewed. So that's who's on CNN or Fox News or whatever. They go, oh, we have this expert to talk about COVID, or talk about this, or talk about that. And so if you have a relationship with a lawyer, say, hey, can we do like a Zoom together and talk about that? And now you have that, and that's a marketing piece for you. See, I was interviewed by this lawyer, okay? Well, you don't have to say I'm an expert. The consumer comes to that conclusion in their mind. You must be an expert if a FCRA lawyer is interviewing you. And so you put that on your website. You get it transcribed. That's on your website. That's part of your marketing material. So, we don't have to say, I'm affiliated or anything like that. I think what Mike said is great. Make sure you're the center of the universe, but then you can have these sort of marketing materials out there that can be very helpful.
Yeah, and I think there's other things just from my experience that over time, I've done paralegal work for law firms. Either it's sometimes the lawyer that I routinely use, he'll sometimes put me as a paralegal on cases, and that gives me the attorney-client privilege. I've had clients who were attorneys, and then they were like, Stephen, I'm just gonna hire you to be a paralegal, but do it under my firm or whatever. You can do that. So you can say, I've done paralegal work. Most states, I don't think even require a license. I'm in Texas, and it doesn't require any certification to be a paralegal. And then also, on the expert side, I've been listed both as a consulting and a testifying expert in different lawsuits that we've handed off to clients. And so, I think as the relationship grows, in addition to just saying, hey, we've had clients and we work with these different attorneys, you're truly going to get different credentials, or I mean, not that those are necessarily credentials, but you're going to get different things under your belt that you can tell clients, and they're better than any certificate you can buy in the credit repair world, in my opinion. To be able to tell a client, hey, I've done paralegal work, I've worked with these different attorneys, I've done expert work, and I've learned it all through my experience, and that's what I'm here to help you out with, Mr. Customer. So Eric says he's willing to work with you if you're willing to work with him. So it sounds like you guys are going to be in a fee bid to see who can do the better deal for him. Let the marketplace win on that attorney competition. But all kidding aside, man, I appreciate both of you guys. Mike, I appreciate you for being our special guest today. It's entertaining and insightful as usual. And of course, John, appreciate you rounding up Mike, and I can only imagine who you're going to bring in next time. You're going to have to start bringing in all these attorney guests. I think our fans are going to really want that. So
we're going to have Mike come in as a cat next time. So
yeah. What do you guys think? Go ahead and comment in here. Do you guys want us to bring in more attorney guests moving forward next time before we wrap this one up? So Jajisa says, thank you both. Well, both, there's three of us, so I'll assume you mean me and John and not Mike. So, but okay, you guys are awesome. Thank you, Alonzo. Thank you, thank you, thank you. You guys are awesome. Great Zoom. All right, cool. So that being said, again, reach out to these two guys and they're definitely here for you. Reach out to me. I'm happy to talk as well. Appreciate all of you guys for watching this, being part of this amazing community. And we will see you on the next video.